Good afternoon. This is Becki Young from Grossman, Young and Hammond, and I'm here with my partner, Sandra Grossman. Today is Wednesday, the 24th of June, and we're here to talk about the new executive order on immigration that was released on Monday, the 22nd. So the title of the new executive order is Proclamation Suspending Entry of Aliens Who Present a Risk to the U.S. Labor Market Following the Coronavirus Outbreak. You might think from the title that this relates to entry to the US, but in fact, on a closer reading, it mainly seems to be focused on visa issuance at overseas consular posts, rather than entry, which is at the border and controlled by US Customs. So that's an important point to note about the executive order. It was effective as of 12:01 a.m. last night, so it's effective as of today. Let's unpack the order. And before we begin, I should also point out that this is not legal advice, and we're providing this video for the purpose of general information, but if you do need specific legal advice, please consult with an immigration attorney. So Section 1 of the order basically extends the previous executive order from April 22nd, which covered immigrants, so people who intend to live in the United States permanently, who were outside the US on the date of the order and had not yet received an immigrant visa. So this new proclamation extends that proclamation until the end of the year. So basically anyone who was planning to immigrate who doesn't yet have their visa cannot come until the end of this year. The new part of this proclamation is mainly contained in Section 2, which extends this ban to certain categories of temporary or non-immigrant workers. And the categories that are impacted are H-1B, which are professional specialty occupation workers, H-2B, which are short-term workers, usually unskilled and low-skilled workers, L-1, which are intercompany transferees, both managers and executives as well as specialists, and also J-1s. And the J-1 category has a whole bunch of subcategories, but this order applies specifically to 6 subcategories, which are trainee and intern, summer work travel and camp counselor, teacher, and au pair. So those 6 J1 categories are impacted by the travel ban, or the entry ban or visa issuance ban, as the case may be. So there are 3 requirements for this ban. The first is that the individual falls into one of those 4 categories of non-immigrants. The second is that they have not yet received a visa stamp in their passport. And the third is that they do not have some sort of alternative form of travel document. So it is important to note, as we talked about the categories that this does apply to, that there are still a range of categories that it does not apply to. Some of those categories include E, O, P, and TN, so just a few to note. The order also applies only to those individuals who are outside the United States as of midnight last night. So in theory, somebody who's in the US in any one of those categories could still travel outside the US, apply for a new visa, and this of course assumes that the consular posts reopen. At this point in time, there really aren't any US overseas consular posts that are processing non-immigrant visas, so actually a lot of this order is still moot at this point until consular posts resume issuing visas. But anyway, someone who is in the US could theoretically travel out, get a new visa, and come back, but the widespread consensus among the immigration bar is that this is a really risky proposition, and we are certainly recommending to our clients in that situation not to travel at this time. One important thing to note is that this order does not preclude a change of status from a different non-immigrant status, such as F or B, to any of the statuses mentioned in the order. So theoretically, first of all, if you're in F1 status and you're changing your status to an H1B, that is fine, as long as it's done in the United States. It's also theoretically possible that you could enter the US in a different status and change to one of the prohibited status, but that has a very specific set of concerns that I'd like Sandra to address.
Thank you, Becky. So yeah, it's critical if someone's coming into the United States in one status with the intent to change to another status, that this would likely be considered fraud or misrepresentation. And that is something that the proclamation specifically addresses, but it's also part of longstanding immigration law. So, for example, entering the US on a B1 visa with the intent to change immediately to H1B status could be considered fraud. Now, in order to show that fraud exists, the government has to show that the immigrant knowingly and willfully intended to violate the terms of his visa, and that they had this sort of preconceived intent. So it's a high bar, but it's definitely something to be aware of given this provision and the likelihood that Department of Homeland Security is going to be looking very closely for fraud when they receive change of status applications.
Thanks, Sandra. I think that's a really important point to keep in mind. We should also remember that a travel ban remains in place with regard to most of Europe, as well as China, Iran, and Brazil. So this executive order will also have little impact for individuals who are currently in those countries, since they cannot travel to the US at this time anyway, until that ban is lifted. The next point that we want to talk about is that this ban applies to individuals who do not yet have visas in their passports. So we have a group of clients who traveled overseas prior to COVID, got visas, or they were already overseas. They got visas and then they got stuck and they couldn't travel. Those individuals will be able to travel once travel becomes possible. However, if you traveled overseas or you were overseas and you have an approved petition or application, but you were not able to get a visa, you are stuck until the end of the year. And that's really unfortunate, especially there's a subcategory of individuals who may have been in the US for quite some time, those in H or L status, for example. Some of them have been here maybe for 5 years or longer. Some of them have US citizen children. And they may have traveled overseas for some sort of emergency reason, got stuck there, planned to renew their visa. There was an article that I read yesterday from an Indian newspaper, which suggested there are about 1,000 Indian nationals in this situation. And the article profiled an Indian mother of 2 US citizen children who has been in the US for about 5 years and is now facing separation from her children for the rest of the year. So that's a really concerning fact pattern. One point that we do want to bring up is that it's unclear whether this order applies to Canadians who are visa exempt and can process at the border. There's no clear authority on that point, and there is a split of opinion in discussions among immigration lawyers. My opinion is that it does apply to Canadians, but there are definitely learned colleagues who take the opposite position. So hopefully there will be some guidance on that point. The order, finally, this provision about these 4 non-immigrant categories applies only to those individuals who do not have an alternative travel document. So one of the documents mentioned is an advance parole, and that would probably be the most common fact pattern, where somebody maybe has an H or L and a pending adjustment, and they have advance parole. That individual can travel on advance parole. So that's fine. There are a few other types of travel documents that we should talk about, and there are also some exceptions to this ban. So I'd like to turn it over to Sandra to address those topics.
Okay, thank you, Becky. So first, following up on the example that you gave of the Indian citizen who is stuck outside of the United States with her children here, kind of facing this separation, there are other types of parole for humanitarian reasons and for significant public benefits. So there's authority in the immigration laws for individuals that are outside of the United States and are ineligible to get a visa, where they can apply to USCIS for a temporary entry into the United States. And the authority for this parole is in the Immigration Act under Section 212D5 for those lawyers out there listening to this. You'd have to prove that you need to enter the United States for a specified period of time, for example, to reunite with your children. and that it is your intent to return to your home country after the parole period has ended. So that might be an example of a humanitarian parole. Significant public benefit would be, for example, if you were cooperating in some law enforcement investigation, or if you were a witness in a hearing before an agency or a court, that might be an example of significant public benefit parole. Nonetheless, it's important to realize that this type of parole is really only going to be available to a very small subset of people who can meet those criteria. Whether to admit someone on a parole or not is completely within the discretion of the U.S. Citizenship and Immigration Services. There's also no right to obtain work authorization, even if you are allowed to come with a parole. You can request work authorization, but whether USCIS grants it is again in their discretion. So it's worth just mentioning for people that are under these exigent situations that this exists. So Becki also mentioned there are some exceptions. There are actually 4 different exceptions to this latest proclamation. The first exception, so the exceptions mean that the people that fall under these exceptions are not subject to this proclamation. The first exception listed is for lawful permanent residents, but this really can be disregarded since they're not going to be entering the United States on a non-immigrant visa. The 3 remaining exceptions are spouses and children of U.S. citizens, individuals seeking to enter the U.S. to provide temporary labor or services essential to the U.S. food supply chain, and finally, individuals whose entry would be in the national interest. So let's just talk about each one of those exceptions. For spouses and children of U.S. citizen, I think we're of the opinion that it would be unusual that you would say have an H-1B spouse of a U.S. citizen, but it's certainly possible. And so they wouldn't be affected by the proclamation. Immigrants who seek to enter to provide temporary labor or services related to the U.S. food chain supply. So I would imagine that here there's going to be a role for immigrants and advocates to make arguments about whether or not these individuals provide services that are critical to the food chain supply. And there's going to be a lot of talk, there already is among immigration attorneys, about what is the definition of food chain supply. So that's something that we're going to be looking out for. As I mentioned, the proclamation doesn't apply to immigrants whose entry would be in the national interest. And this is where the proclamation actually directs the Secretary of State, Labor, and Homeland Security to determine standards for those whom an exemption would be available, and factors that they would look at. They're going to consider any individuals who are critical to defense, law enforcement, diplomacy, or national security of the United States. They may exempt individuals involved with the provision of medical care to individuals who've contracted COVID and are currently hospitalized, so people in the medical profession. And they're also going to consider individuals that are involved in medical research at US facilities, and also listed as being exempt under the national interest factor are individuals who are necessary to facilitate the immediate and continued economic recovery of the United States. So there is some room there to make arguments about being a part of this national interest exemption. Finally, children who would age out of eligibility for an immigrant visa because of the proclamation that this administration passed in April would also be exempted. So Becki, why don't you talk a little bit about Section 5 of the proclamation and give us some details about what that's all about.
Absolutely. So, and in fact, I will cover Section 5 and a few subsequent sections. So what we just covered is sort of the meat of the proclamation and what the media has largely been covering, but there are a few other gems, that if you'd like to call them gems, a few other nuggets that are contained within this order. So one of them orders the Secretary of Labor to do a few things. The first is to examine whether H-1B workers and also workers in the EB2 and EB3 categories, which are largely perm-based categories, are unfairly taking jobs from US workers, and it orders the Secretary of Labor to consider promulgating regulations or taking other appropriate actions with regard to anyone admitted in those categories who may adversely impact the US labor market. So that language is a little bit broad and a little bit concerning. It says, the way that the language is drafted, it almost suggests that they could intend to apply it retroactively. That would clearly be challenged in the courts and would almost certainly be found not allowed, but the language did concern us. It also asked the Secretary of Labor, in essence, to step up LCA investigations, so investigations of the Department of Labor portion of H-1Bs to ensure that workers are in compliance and that employers are in compliance with their LCA obligations. And that's really important because during the pandemic, a lot of workers maybe started working from home work sites or other work sites that were not contemplated by the LCA, or there were changes in the wages or working conditions, all of which is required to be documented in the LCA compliance file. So employers should really take a hard look and make sure that their LCAs are up to date and up to par at this time. There's another little provision that suggests that biometrics should be required for basically anyone applying for any sort of benefit or entry. And as far as we can tell, what this is suggesting is that they might intend to start doing biometrics for I-129 beneficiaries, so foreign workers whose employers petition for them to work in the US, for example, in H-1B status. Almost every other category of immigrant and non-immigrant is already subject to biometrics, so that's the only category that we came up with that isn't already subject. The last point, which is interesting, is that it suggests that they're going to take a look at how H-1B cap cases or cap numbers are allocated. So right now there are 85,000 numbers each fiscal year, 20,000 of which are reserved for masters, individuals with US master's degrees, and the remaining to individuals who have at least a bachelor's degree, either US or foreign. So it appears that they do intend to look at that allocation and maybe think about different ways to allocate those H-1B numbers. I think one concluding comment that I would like to make is that a lot of what's in this order will be very dependent on the election. H-1B cap cases will not happen again until March of 2021. So depending on what happens in the election, this administration may or may not have an opportunity, we hope they do not, to impact what will happen with next year's cap allocation. And with that, I will turn it over to Sandra to talk about a few remaining provisions of the order.
Right, so I get to talk about some of these additional kind of nuggets, as Becki said, that seem to have been included at the very end of the proclamation. And I'm of a very similar opinion that I think a lot of these provisions are going to be difficult, if not impossible, to actually enforce. So one of the additional measures that is included in the proclamation is that there's an order for the Secretary of DHS to take steps consistent with the law to prevent certain individuals who have final orders of removal, who are inadmissible or deportable from the US, who've been arrested for, charged with, or convicted of a criminal offense from being able to work in the United States. So there's this whole other category of individuals that the administration is trying to prevent from obtaining work authorization. As far as we can tell, this really has nothing to do with what they purport to be the original intent of the proclamation, which is to prevent the entry of non-immigrant temporary visa holders. So this provision, if it's enforced, could potentially be very far-reaching. So, for example, the provision talks about preventing individuals who have final orders of deportation from being eligible to work. So that could prevent, so individuals who have applied for and have been granted relief under the Convention Against Torture, they currently have the right under the regulations to apply for work authorization. And if this were applied, that could conceivably be prevented. Other individuals who are in deportation proceedings. So for example, they've been charged with inadmissibility or deportability by the Department of Homeland Security. It's unclear at this point whether those individuals, say if they have pending applications for some kind of an immigration benefit, like cancellation of removal, for example, or if they were conditional permanent residents who were referred to removal proceedings, those individuals normally have the right to apply for work authorization. So with this provision, it's possible that they would be denied the ability to apply for work authorization. And the same could hold true for individuals who are in removal proceedings who have applied for asylum. Under longstanding immigration regulations, those individuals could apply for work authorization after 150 days. That was recently changed in accordance with a new rule that was promulgated recently and is supposed to go into effect at the end of August. Those individuals would normally, will now not be allowed to apply for work authorization until a year after their asylum application is pending. But again, if this provision goes into effect and if the administration has a chance to implement it, if depending on results in November, again, it's possible that those individuals would not be allowed to obtain work authorization. So, and then just very briefly, I mentioned there's a section there on preventing individuals who have been arrested of certain criminal convictions or have been arrested of certain criminal acts or convicted. So that again has the potential of reaching a very broad swath of people. There's a final section in the provision on severability. So here, it's our opinion that the drafters of the proclamation are clearly trying to insulate the order from litigation. It is true that the president has the authority under the Immigration Act to exclude immigrants from the United States by proclamation whenever he determines and for how long he determines, as long as he can make the argument that their entry would be detrimental to the interests of the United States. This provision and the president's authority was upheld by the US Supreme Court most recently in the Muslim travel ban cases. Nevertheless, as Becki has talked about and as I have mentioned, the scope of this proclamation seems to go well beyond denying entry to immigrants and is actually abrogating the required rulemaking procedures, which the Supreme Court also recently upheld in the DACA or the Dreamers decision. So in the severability provisions, I think the administration itself recognizes that they're likely to be sued for many of the provisions. And they actually state that if they are sued or challenged on any particular part of the proclamation, the remainder of the proclamation will continue to be valid. It's very unclear to me where or how they have the legal authority to make this kind of statement, and we expect it to be challenged. In a final provision in the severability section, they also state that if anyone files a claim against them because of a procedural irregularity, then they will just turn around and implement the required procedures. And I think this is a nod actually to, again, the recent DACA litigation, where the majority of the court found that the government had acted in an arbitrary and capricious way, not because they sought to end the DACA program, but because they didn't follow the required procedures. So I think in the case of this proclamation, that's again a worry and a place where we can certainly expect judicial challenges to, especially to the provisions that really have nothing to do with non-immigrant entry to the United States. So that provides you hopefully with an overview of the proclamation and our analysis. We will continue to provide updates and analysis on the quickly changing immigration landscape, and we thank you for listening in.
Thank you very much. Have a great day.